David Lane, ready for petitioner Michelle Reyes.
Tanisha Taylor appearing and ready for the respondent, husband, father, Hector Gomez Ayala.
We are set here today on the final trial. The only remaining issues before the court are child support, possession and access, and conservatorship.
Parties were married, they divorced, and then they remarried. So this is actually the second divorce for the parties. There was a prenuptial agreement dealing with property that was also memorialized in the partial mediated settlement agreement. So all property issues are resolved. We are asking the court today to grant a divorce on the grounds of insupportability and to award the property as issued in the partial mediated settlement agreement. The only remaining issues is the child custody evaluation, child custody, possession, access, and support. Since the time of their decree, the parties have been operating on a 50-50 basis. We did conduct a child custody evaluation, which has been admitted into evidence. And we are simply asking the court to honor the recommendations of the evaluation and appoint mom as both parties as joint managing conservator, but mom is the party with the right to designate the primary residency and to grant dad the expanded standard schedule and to set child support for dad to help out. With that, I'm closed my opening statement. Sorry.
Thank you, counsel. Attorney Taylor.
Yes, Judge. So, as Mr. Lane mentioned, the parties were divorced previously, and there's a divorce decree from 2017.
This case is far more complicated than it first appears. We're not just watching a custody dispute. This is the second divorce between the same two parents, with years of shared history, unresolved conflict, and a 10-year-old child caught in the middle. Both sides claim stability. Both sides say the other is the problem. And both sides point to the same word over and over again: best interest. As this hearing unfolds, pay close attention to credibility, consistency, and timing, because those details may matter more than any single accusation.
And again, since that time, neither one has asked to modify those orders. Your Honor, which has been, the custody evaluation has already been admitted into evidence, but if you in that evaluation, the basis for changing the possession and access and making mom the primary conservator is based on an unqualified statement that the father works a lot. But you will see that there is no breakdown of the father's hours, no mention of the father missing any important milestones or school activities or not being available for the child. In fact, you will see in that evaluation, it says the child is fully well adjusted to this schedule, and he's bonded to both parents, and both parents are equally active in his academics, extracurriculars, and in his life. Also, you will hear testimony today that there has been changes since that schedule, where during the evaluation, mom was not working at all, and she had just accepted a severance from her position, where now she is working and she is utilizing childcare for the child, where it puts her and father in a similar position, where the recommendation is now stale because it's based off of facts that are no longer relevant. Additionally, we submitted a summary, but just to revise it a bit, my client is really just asking for this court to maintain what the child has been used to. He's 10 years old, and 6 out of the 10 years of his life.
Opening statements frame the entire battle. Mom's attorney relies heavily on the child custody evaluation, treating it as the clearest roadmap for the court. Dad's attorney takes a different approach, arguing that the child has thrived for years under a 50-50 schedule without emergency issues or modification requests. This isn't about whether both parents are capable. It's about whether change is necessary at all. From the start, the court is being asked to choose between professional recommendation and lived routine.
Call Michelle Reyes to the stand, please.
Okay.
May I share Alexander?
I do, yes.
Does your work schedule prohibit you from being able to pick up Alexander or take him to school?
Not at all. There's times where I've been able to bring him to work with me if he got sick at school or if like there was no school and I had no other choice.
Do you know approximately, so you've been married to Hector twice, do you have an idea of how much money Hector makes a year?
I really don't know, but I mean, just from
Objection and speculation. She just testified she doesn't know.
Sustain.
You don't know, you currently don't know, is that right?
Correct.
When you were married to him before, what was he making?
Objection, can we get a timeline as to when or what year he's referring to?
During your first marriage?
Prior to 2017? If that's the case, I'm going to object to relevance.
Sustain.
What was he making before your current marriage separated?
Excuse me. I really don't remember what he was making.
Mom's testimony shifts the focus from schedules to communication. She describes co-parenting as exhausting, claiming dad is controlling, dismissive, and unwilling to compromise. These statements are meant to show emotional instability in the co-parenting relationship, not just logistical issues. But notice how subjective much of this is. Courts require more than frustration. They look for patterns, proof, and impact on the child. This testimony invites sympathy, but it also invites scrutiny as the questioning continues.
Currently working, but you would agree that during the custody evaluation, you indicated to the evaluator that you were not planning to go back to work. Is that correct?
That is false. I never said that.
At the time of the custody evaluation, you received a severance from your then employer and you were taking time off of work. Is that correct?
Yes.
And then also you would agree that the basis of the custody evaluator's recommendation is that you had more availability at that time than Mr. Gomez. Is that correct?
I believe so.
And additionally, now that you are working, how many days a week do you have a nanny or your neighbor pick up Alexander from school?
My sitter picks him up Monday through Friday from 3:30 and I get home at 5.
And how far do you live from the school?
Taking in traffic, it is like a 40-minute drive.
So now you would agree that you and Mr. Gomez both utilize childcare on some days during your weeks. Is that correct?
Yes, but not the same amount.
Now, you also mentioned that you have gotten several calls from the school regarding Alexander being needed to be picked up. When is the last time you got a call from the school during Mr. Ayala Gomez's time?
Work schedules become the central battlefield here. Mom portrays dad's restaurant ownership as demanding and unpredictable, suggesting it interferes with parenting. But when pressed, she admits she doesn't know his current schedule. That's important. Judges don't rule on assumptions. Meanwhile, Mom presents her own job as structured and predictable. The implication is clear: availability equals stability. But flexibility can cut both ways, especially when ownership allows control over time rather than rigid hours.
I believe that was Christmas of 2024.
And Alexander what school is he currently attending?
Holy Trinity Catholic School.
And how long has he been at Holy Trinity?
Since the 3rd grade. He's in 5th now.
And you would agree that overall, academically, he's done well at Holy Trinity. Is that correct?
Yes.
And then during both parenting time, he's been able to maintain his academics and his attendance at school. Is that correct?
I can't fully agree with that.
And additionally, you two have been under this schedule since January of 2024, and you nor your attorney on your behalf has requested to modify the schedule at any time. Is that correct?
Yes.
Now, you also would agree that Alexander is well adjusted to the week on week off schedule. Is that correct?
I don't know how to answer this because if you talk to him, he'll be like, yes, he's very political in that way. But last night he was
objection and non-responsive.
Now
you would agree that for at least almost 6 years of his life, he he's operated under a week on, week off schedule with both you and dad. Is that correct?
What was the time frame you just said?
For almost 6 years. So from
Cross-examination exposes cracks in the narrative. Mom acknowledges that since the custody evaluation, she is now working and regularly uses childcare, the very facts that once supported the evaluator's recommendation. That raises a serious question. Is the recommendation still current? When answers become vague. A handful of times I don't recall. Credibility takes a hit. This isn't about proving someone wrong. It's about whether the court can rely on the picture being presented today.
I just think he has better stability in one home.
now, also, you understand that Alexander has siblings in dad's home, correct?
Yes.
That he is also bonded to, is that correct?
I don't know their dynamics.
Wouldn't you agree that changing his schedule could impact him emotionally and academically?
I don't think so.
And now, as far as your income, how much are you currently making with your employment and your ownership in the restaurants?
I'm really not sure.
Can you give us a guess?
Can we just say like 100 a year?
And additionally, since the temporary orders, you and Mr. Gomez have split Hector's tuition 50-50. Is that correct?
Yes, but there's been some things happening. Something happened.
And isn't it correct that you two have taken, you've paid 6 months and then he's paid the other 6 months, correct?
Yes.
And then there's been no request for additional child support since the temporary orders, correct?
Right, but there's been stealing on the other party's part.
Objection non-responsive.
The same.
Now, as far as the evaluation, the evaluator also...
Mental health testimony instantly raises the stakes. A diagnosis alone doesn't disqualify a parent, but compliance and transparency matter greatly. The court now has to consider whether treatment recommendations were followed and whether mental health is being raised as a genuine concern, or used as leverage. Judges are cautious here. They weigh stability, accountability, and honesty. This moment forces the court to assess not just parenting ability, but judgment and responsibility moving forward.